buenos días.
Good morning, colleagues, members of the Secretariat, conference services, observers here present. I would like to welcome you very warmly to this morning's meeting. This is meeting 3213 of the Human Rights Committee. This is a public meeting, at least the first part. That means we will be meeting in public session until midday, 12, to address the draft General Comment 36, which concerns the right to life. At the outset, I would of course like to express my gratitude to the co-rapporteurs for their work, Mr. Yuval Shani and Sir Nigel Rodley. They have prepared a very significant, interesting draft which they put forward to us for consideration. The work that goes into preparing a general comment has to be some of the hardest work faced by this committee. The rapporteurs on the general comments have an enormous amount of work on their hands. It's not simply a matter of ruling on a case, concluding observations on a state. It's more than that. It's a matter of compiling information on provisions of the covenant, the protocol, as well as an updating of the information concerned to enable us to be in line with times, to move with the times. General comments can serve as extremely useful guidance not only for the committee but also states in public policy making. Of course, each and every one of us would come up with a separate, different draft were we to be let loose on it. It's very difficult, therefore, to ensure that we can all be reading from the same page. There's a huge amount of work involved in consulting with civil society and various stakeholders, and having considered the first draft, a new second drafting process will be begun with another round of consultation with civil society as well as state parties who are given the opportunity to address the committee. This is the first step. It's far from easy, but hugely enriching. Allow me once again to thank Mr. Shani and Sir Nigel Rodley for the excellent draft that they are putting forward here. I would like to give the floor at this point to both of the rapporteurs to present the work that they have undertaken, and I would like to give the floor first to my dear colleague Yuval Shani. You have the floor, Mr. Shani.
Thank you, Chair. I will try to be brief because I already understand that one of the main challenges for rapporteurs would be to find enough time on the floor to discuss this. It's a big document, and it's going to require us a lot of time. So I'll try not to sabotage our own cause and be brief. Let me say a few words about the methodology and about some of the issues I want to flag, and then Sir Nigel will continue and make his own introductory statement. In terms of what you have before you is a draft which tried in terms of structure to follow the structure that the committee used in General Comment 35, which was the most recent general comment that we have adopted, that was also prepared in a manner that was well organized. So it was, for us as drafters, it was a very convenient point of departure. It also, I think, is useful for the committee to adopt, where possible, the same structures in discussing the various articles within the general comments. Of course, here and there are differences. The second point I want to make, we have tried as comprehensively as we could to cover all the output by the committee, certainly all the views were in which Article 6 were was mentioned were reviewed, and all the concluding observations. We also paid close attention to the other general comments. Of course, we try to be as careful as we can in distinguishing views and concluding observations. And some of the language is more obligatory, and some of the language is more recommendatory, and the footnotes vary in accordance. Because of space and word limitations, we could not refer in this draft to all the sources. So once we had a proposition which was, for instance, endorsed by one or two views, we did not cite all the other, sometimes 20 or 30 views that endorse the same point. So but I can assure you that we did try to capture everything in terms of the committee's output. Now, we also tried to enrich this draft as much as we can by also looking at the work of other treaty bodies and also other relevant special procedures. So this draft represents, to some extent, also the outputs of their work. And especially in areas where the committee's work has been less extensive, we did look into the practice of other regional bodies that deal with human rights. And I'm sure that once we will get to some of these specific issues, we will have to discuss. But we did not blindly endorse the regional outputs, but we did consider them, and we did introduce, I believe here, some ideas which have been developed in the European regional system, in the Inter-American regional system, and also in the African regional system. We also consulted in terms of methodology the travaux préparatoires in order to, at least where the text is unclear, to draw some inspiration from the preparatory work. Now, we already received some comments from committee members, and we've already received also some comments from other special procedure mandate holders, and we already received some comments from desk officers within the office who are working on related issues. This has already led us, with regard to some issues, to reconsider some of the terminology that we are using. And when we will go along the first reading, we will offer already some minor changes on some provisions. I can already flag paragraph 7, 10, and 28 as paragraphs on which we would probably circulate some mildly revised draft, which would try to harmonize the language that is used in this general comment with the language that is used by other parts of the same UN system. We have also been, and I'm sure that many of you have already been approached by civil society at this point in time. And here perhaps I can say something. We have, in the interest of transparency and in order to enable the audience that is following these proceedings, these sessions, both here in the room and also on webcast, we uploaded the rapporteur's draft in order to allow those interests to follow the discussion. But this is not the point in the process in which we actually solicit interventions. As the chair has mentioned, once the first draft would be adopted by the committee and it will become a committee draft, then there will be ample opportunity for all stakeholders, non-governmental organizations, as well as member states to submit formally their comments and observations on the draft. So at this point in time, we would not, at least from our point of view, we would not try to accommodate any specific communication, because the process has not been opened for these inputs to be forwarded to us. For the new members, perhaps who were not here when we have discussed General Comment 35, Perhaps I want to say two things about the process which are important. First, the adoption of general comments is by and large based on consensus among committee members, which means that in many areas we will be adopting language that does not fully reflect the individual views of each and every committee member, but they would by and large hopefully reflect the views of the committee. That's why the role of jurisprudence, the role of precedents is very important, because it actually reflects the views that a committee as a committee has adopted on these issues. I would urge all of us to try to approach this exercise in the spirit of cooperation and where needed flexibility. Of course, we are all fighting very hard for the specific issues that are important to us and are important for human rights. And the last point perhaps I want to make is that some of the comments which we already have received, as I indicated, have made general claims about whether human rights should protect certain interests, etc. We are dealing here in a way, we have to remember that this exercise is about the interpretation of a specific article in the covenant, Article 6. It cannot therefore encompass all aspects related to the covenant or all aspects related to human rights. So for instance, issues of immigration or issues of public health will be addressed in this context only to the extent that they interface with Article 6, and we cannot address all of the relevant aspects of these very important issues in connection with this general comment. I think I will stop at this point in time, and I will return the floor to you, Chair, and I assume you will then provide Sir Nigel the opportunity to speak.
Muchas gracias, señor.
Thank you very much, Mr. Shani. I will, of course, be giving the floor to Sir Nigel. But I would like to say to colleagues who are working with the Spanish and French versions of the draft that in the English version, footnotes are included. These are not to be found in the French and Spanish versions. So could I suggest that those working with the Spanish and French versions also have the English version to hand, because it will be easier to check up on the references made by the rapporteurs in their draft. Once again, my thanks to Mr. Shani. I would now like to give the floor to Sir Nigel Rodley. Sir Nigel, please.
Thank you very much. Excuse me. Thank you very much, Mr. Chairperson, and thank you particularly for mentioning that that last point, which was going to be my first point. The reason that the French and Spanish versions aren't footnoted is just simply the word length problem. The document is simply too long to be translated. It cannot be officially translated because of the word limits now imposed by the General Assembly in Resolution 68/268. So this is the unfortunate compromise. There was already a problem even before that resolution. Colleagues will remember from the General Comment 35, which was overcome in a rather complicated way with footnotes being inside the text, outside the text, and this is the solution that we have this time. And clearly, because the footnotes are just references, they perhaps don't pose the same linguistic challenges as the main text itself. So I hope Hispanophone and Francophone and Arabophone colleagues will be able to work with the two texts that way. I just want to say a word about process. I have nothing to add to what Mr. Shani has said about substance. And maybe a bit of background is in order, both for new colleagues and for and for others who are following us in the room and outside the room. Until General Comment 31 at the beginning of the 2000s, while discussions in the committee were public, the document they were discussing was a restricted document and it was not in the public domain. Through first reading and through second reading, there was no consultation process until General Comment 31, when a consultation process was initiated between the first and second reading. But still, for the next few general comments, we found that we were still discussing a document that until the end of the first reading was not publicly available, which made it difficult for those outside the room to follow what was going on. Those inside the room had access to the document, even though it wasn't a public document. So we decided this time to make the document public from the beginning, and that has led to an assumption, perhaps, that we're ready for the sort of input that in fact we'll only be ready for at the end of the first reading. Obviously, colleagues are approached on all sorts of things in the work of the committee, whether it's country work or general comments or whatever, and that's fine. They can take on board whatever ideas they receive from whatever source, and participate as any expert does on the basis of such information and ideas as he or she has been able to glean. The point is that we are not at the stage of taking on board formally submitted or even informally submitted material from NGOs, from various kinds of organizations and constituencies, and so there's no requirement that we address those, and indeed it might not even necessarily be appropriate to address them by name. But obviously there's no reason why any one of us can't be sufficiently impressed by something that we read that then encourages us to make suggestions. That applies to all of us, including the rapporteurs, as we've heard already from Mr. Shani. So that's it. It's the most transparent process we've ever had, and I think that's a good thing, even if it has perhaps misled some to believe that they're going to be able to have a more influential input than may actually be the case at this stage. Obviously, when we get to the end of the first reading, then that will be open day for anybody to come in and submit material to us, and that will have to be taken on board by the committee in the same sort of systematic manner as we have done in previous second readings. But that's for then, not for now. I think that's all I want to say. Look forward to a very interesting discussion, and I presume that what we will do is start off with a general discussion, and then we will go through paragraph by paragraph, with the rapporteurs being asked if they want to introduce any particular paragraph. Do I have that right, Mr. Chairperson? Thank you, sir. Thank you for giving me the floor.
Muchas gracias.
Thank you, Sir Nigel. No, you are absolutely not mistaken. This is indeed the procedure we will be following. Allow me to thank the rapporteurs for their opening remarks. I would now like to open the floor for general remarks. to enable general comments to be made on this draft. We will then move to a consideration of individual paragraphs. I would therefore like to invite at this point committee members to speak in general terms on the draft. I have two requests for the floor. The first is Mr. Olivier de Frouville. You have the floor, sir.
Merci beaucoup. Chair, thank you very much. First of all, I would like to commend or extend a heartfelt congratulations to Mr. Chani and Sir Nigel for the huge work they've done in drafting this general comment. It attests in itself to the appropriateness of the committee, which the choice of the committee, which 32 years after having adopted General Comment 6 and 30 years after adopting General Comment 14, has decided to adopt a new General Comment on the right to life. It was time, indeed, to take stock of the mushrooming jurisprudence of the committee on this issue, which comes both from its concluding observation on state party reports as well as from its observations on the communications submitted under the optional protocol of the Covenant. Now, the challenge was a sizable one given the number of issues adopted by the committee from the angle of the right to life and given the extreme complexity of most of the issues raised thereunder. The rapporteurs chose to propose to us from the very start a comprehensive draft which tackles all the matters already identified in the list adopted by the committee at its 114th session. They need a lot of courage, even perhaps we could say recklessness, to tackle so many difficult issues that refer us back to very complicated issues, both from a legal point of view, but also from a moral and political point of view. Mr. Chairman, the committee is tackling today this issue in the context which, let's be candid, is not favourable to the realisation of the right to life. Whilst it is true that the last decade of the 20th century was favourable to the expansion of human rights, the 21st century has opened up with the devastating manifestation of global terrorism that has made the violation of the right to life its main raison d'etre. So rather than answering by strengthening the human rights framework in deepening multilateralism, deepening international cooperation, what the international community has done is to become divided, and unilateralism has dominated. States want to circumvent law to defend their own interests. Rather than justice, we've spoken of vengeance. Rather than speak of dealing with the root cause of evil, we've attacked all the symptoms only through all means without giving due consideration to life itself. With this widespread rationale of self-defense, the attacks on life has justified other attacks on life, taking the world into a downward, deadly spiral. This spiral gradually has created a climate, an atmosphere of constant insecurity. The preservation of security has taken hold in our lives and has taken priority over the respect of rights. Fear generated by insecurity is becoming pervasive, has pervaded everything. And with fear, we've become afraid of other people. And we've started to look at the past when we had security, and we've started to long for that past. The state of emergency, which legally used to govern extraordinary and rare circumstances, have become progressively the rule, as was predicted by Walter Benjamin. In this extremely difficult context, our committee has a duty not to give in to regressive tendencies, but rather to reaffirm loud and clear the right to life as a primary right at the heart of human rights, which are indivisible and interdependent. Almost every one of the points raised in our general comment, or rather our draft general comment, is the subject of significant controversy. And it means that the committee needs to take a clear position, and the committee needs to be faithful to the spirit of the Covenant as it was expressed by the drafters thereof almost 50 years ago. I would just like to refer to 3 points here. 3 points. I don't want to take the floor for too long. These are just examples. It's not comprehensive. First, the death penalty. On this point, the draft reminds us, rightly so, the abolitionist spirit of the Covenant. In paragraph 52 of the draft, we read, and I quote, "The death penalty cannot be reconciled with the full respect of human dignity, and its abolition is desirable and necessary for the promotion of human dignity and the progressive realization of human rights, including the right to life. It would appear that so the Covenant regulates the death penalty not as a legitimate limit to the right to life, but rather a necessary evil or as a fact which imposes itself and means that we need to surround it with a number of strict conditions before it can be definitively abolished. Now, of course, this is the point on which we can be most hopeful or optimistic. Fewer and fewer states are now opposed to the idea that it is necessary for at least to establish a moratorium on executions. But nothing has been achieved forever. We can't rest on our laurels here. Regressive tendencies can still arise in the given context of today. That is why our jurisprudence is key, as we are reminded in this draft comment. It must lead the states to progressively conclude that the death penalty is not compatible with the principles recognised elsewhere in the Covenant. Its abolition and the ratification of Protocol number 2 are, in fact, in reality, the only conclusions we can reach logically, or a state can reach logically. Second question, the right of women to dispose freely of their bodies and abortion. The recognition of the fact that women have rights over their bodies and a right to use abortion is a major achievement, and we should not compromise on that, because it's one of the indispensable conditions for the construction of real equality between men and women. So, what are we speaking of here when we're speaking of abortion in relation to the right to life? Well, let's speak of this clearly. The criminalization of abortion is not designed to discourage women from resorting thereto, but the effect thereof is that it wants to prevent them from resorting to it in conditions that are dangerous for their health or conditions which could lead to their death. There are 22 million abortions practiced every year in hazardous conditions. There are complications due to these abortions in these hazardous conditions, which means that every year 47,000 women die. These deaths could have been prevented if the state had respected their obligations under Article 6 of the Covenant. The priority, therefore, is to legalise abortion to enable women to resort to abortion in conditions that don't jeopardise their life. And in parallel, family planning programs and reproductive health care must be developed, making it possible for people to have more access to contraception. Third point, Mr. Chairman, I'll conclude with this. The right to life in armed conflicts, which covers many very difficult issues, and on that the world is constantly threatening to regress. Let me just raise one of these issues, namely nuclear weapons. The proliferation of nuclear weapons has reached a paroxysm, and a growing number of weapons have access to this weapon, likely to destroy the whole of humanity. And tomorrow, perhaps even today, these non-state actors might get hold of nuclear weapons and make it a weapon of terror. More than ever, the words used by the committee in general comment number 14 are therefore topical, relevant today, and must be restated. And I'll quote these once again. It is obvious that the conception, the testing, the manufacture, the possession and the deployment of nuclear weapons constitute one of the serious threats against the right to life that humanity faces today. The manufacture, the testing, the possession, deployment and the use of nuclear weapons should be prohibited and described as crimes against humanity. End of quote. I thank you, Mr. Chairman.
Muchas gracias, señor de Frouville.
Thank you very much, Mr. de Frouville. Mr. Iwasawa, you have the floor, sir.
Thank you, Mr. Chairperson. First of all, I'd like to congratulate Mr. Shani and Mr. Nigel for the work they have done. We're grateful for the enormous work they have put into this draft. This is a good draft. It forms a good basis for our discussion. I'm sure we will have a very interesting discussion. I'd like to make some comments on the process. Mr. Chair, you and Mr. Shani, both Mr. Shani and Sir Nigel, explained the process very well, so I have little to add. I've been on the committee since the time when the committee was discussing General Comment 32, so I've been through some of the general comments. as Sir Nigel explained, that we now have first reading and second reading, and we ask for comments after the first reading draft, comments from the state parties, stakeholders, and others concerned. So we have a formal process for and a process asking those who are concerned to make comments. Since last general comment 35, we have started to put our draft on the web, but it's only for information only. We didn't do that until 34 because we constantly revise our draft at every session, and different versions will be available for members. And if people concerned start making comments on the older versions, it becomes very confusing. So what we did was to make the first reading draft available to the people concerned, and formally asked for their comments on the first reading draft. So I'd like to stress once again the point made by Mr. Shani. The draft is available on the web for information only. It makes sense because it's a public meeting, and this is webcast. And unless people have a draft before them, it's difficult to follow the discussion. The committee, unlike other treaty bodies, this committee has had discussion on general comment always in a public session. Some other three bodies are having discussion in a closed meeting. We have had general comment discussion in a public meeting. So for this, we are transparent. But for the reason that I gave, the draft were not available before. And for the reason that I gave, webcasting, and this is a public meeting, this draft is available. But I'd like to stress once again that people will have a formal opportunity to make comments at the end of the first reading. So we're not really soliciting comments from people concerned at this point, but it will anyway enrich our discussion. Thank you very much.
Muchas gracias.
Thank you very much, Mr. Iwasawa. Mr. Benachur, I'd like to give you the floor. You have the floor, sir.
Merci, Monsieur.
Chair, thank you very much. I also would like to congratulate Mr. Shani and Sir Nigel for this work they have accomplished and which we have before us today, and as my colleague have said before me, will be for us an excellent basis for which we can have discussion. And I think it's pretty final for a first draft. It's pretty wealthy in content, and I believe that with the method that has been adopted by these two co-rapporteurs, we'll be able to work a lot faster in the future. As I say, this is a pretty tight general comment at this stage. At this stage, I'd just like to address issues of methodology. I won't address issues of substance. Of course, as Mr. de Frouville pointed out, there are several issues of substance which, in all likelihood, are controversial in nature. But I feel that the rapporteurs have adopted balanced and nuanced positions that take into account the committee's jurisprudence, and in particular, referring to the paragraph on abortion, number 7, paragraph 7, I reread it probably around 10 times to really see what I could say on it, and at the end of the day, I find it to be a balanced paragraph. So, as I was saying, methodology and form, comments relating to form at this stage. I'm very much in favour of us to continue the general debate before going through the general comment paragraph by paragraph. That's a good method. And as to the general structure of the text, personally, I agree with the structure adopted. And in particular, this is something that wasn't self-evident, but the rapporteurs have chosen to structure it the way they did, and namely, they distinguished between the prohibition of the arbitrary deprivation of life and the obligation to protect life. That could have been put under the same title and it would have given us a longer title, but they have nuanced it, and I therefore support the rapporteurs in their approach. I also support the general structure of the whole text, which has adopted a title separate from just the death penalty. We could have discussed that, but given the importance of this issue, it needed to be given a title that was separate from just the death penalty. So I agree with the general structure of the text. I also agree that civil society consultations, as well as consultations with other bodies, this consultation take place after the first reading. I agree with that. Finally, I would like to make a comment on the versions of this general comment, that is the linguistic versions. Personally, I work on the French version, but I'm also very pleased to have side by side the English version. I hope all members of the committee have done the same. The text was drafted in English. We have professional translators, of course, at the UN who have done a sterling job. However, there can be times where some translations might not be entirely agreeable to us. Somebody like me, for example, I'm a francophone, 100% francophone, and let's say, yes, I'm Anglophone, 60% Anglophone. So it's good to have the English and the French versions for us to have a look at the details of the translation. With General Comment number 35, we adopted General Comment 35 at the time, but we didn't really look carefully at the French translation. We didn't give it our seal of approval at the time, and I recall that with the Secretariat I'd gone over a number of the translations, and in fact I worked quite hard on the final French versions for that translation to be good, because despite the professionalism of the translators, there still might be some issues that they haven't got quite right in the language in which we are specialists. So I believe all members of the committee should have before them the English version and their own translated version, French or Spanish, so that we can both discuss substance and at the same time that we can really monitor the quality of the translation or the accuracy of the translation in our view. As I said, I was only going to raise methodological issues at this stage. When we move on to the phase of our paragraph by paragraph discussion, then of course at that point I will share my views with you on the issues of substance raised by this draft general comment. Thank you.
Muchas gracias.
Thank you very much. Mr. Rodriguez Recia, you have the floor, sir.
Sí, señor.
Thank you, Mr. Chairman. I wanted to speak last. I don't know if I am last because I knew that many of the people who took the floor before me would raise issues much better than me. Of course, I'm delighted at this stage to extend a heartfelt congratulations to these two co-rapporteurs. I call them the Club of the Brave Men, because to come up with such a brave draft on the right to life, in my experience, is extremely bold. I saw what happened with General Comment 35, and as Monsieur de Fourville said, this is reckless. It's you're likely to be subjected to psychological torture in public in doing so. So, congratulations for this work. This is brave, bold work. It's very complicated work. The right to life is that. The right to life is the right that summarizes all the other rights. And I wanted to make some comments in that respect on both form and substance, and rather the way we should interpret this analysis that the co-rapporteurs have made. Now, if we're going to analyze the right to life, after so many years after the other comment, is because we need to build a view of the right to life. It must move from a vision which is biased or limited to the obligation of the state not to kill, and that's significant. We must have that shift. Now, this is a very complicated task, and the committee needs to be creative in that endeavour. And we need to ensure that people can live with dignity. What Mr. Benachur was saying, that's what protection of right to life is. You don't just want to enable people to breathe and walk. They need to have a life project that is dignified. That's what the state must do. So one of the first comments I would like to make on that interpretation is in connection with paragraph 5 of General Comment 6. Paragraph 5, General Comment 6. And I would like to keep that particular paragraph, to keep it or improve it if that is possible. This paragraph says that the committee has, the view of the committee was that very often the right to life has been interpreted in a way that has been limited or narrow. And this must be, anything that's inherent to the right to life must be interpreted broadly and not restrictively from the point, just from the point of the right to property, for example. A very important cross-cutting issue is the adoption of positive measures to protect the right to life. That is the issue, I believe, the main issue that should be something we should remember throughout this general comment. And in relation to that, I have another point to make. It's a cause of concern for me and a cause of great interest for me. It's the link between the right to life and the right and economic, social, cultural rights, that link between those two categories of rights. So throughout our discussion, I'm going to be speaking, and I hope it'll be constructively, of what I would like to flow from this general comment, this general draft, and what I want it to achieve, and what I want every paragraph to achieve. And I'll take the floor on each of these when the right time comes. What I'd like us to have is to have a first paragraph that could explain the right to life as being a synthesis right, that summarizes the others, which also guarantees the right of people today to live with dignity. And this right to live with dignity covers also this realization of the it's rectifying the 1966 bias, whereby there's a barrier between economic, social and cultural rights and civil and political rights. This gap has been disappearing, and we don't want to encroach on the competence of other committees in that respect. But our committee needs to be able to say how it sees the right to life and be able to link it to other rights such as the economic, social, cultural rights, especially for those groups who are vulnerable groups. And this is the aim, and I would like this to be more comprehensive, more holistic in our approach. We need to work, therefore, we need to polish this in that respect. So I think we should have a first paragraph on the description of the right to life as a synthesis right, a summary right. I think that would give us a very good added value to this general comment. There are a number of other issues that I would like to analyze from the methodological point of view, it being understood that in the Spanish and French versions we don't have the footnotes, as we have heard. Now, I don't know if we're going to use this general comment as a draft, as a systematization, so to speak, of the committee's jurisprudence or not. And I don't know to what extent we can be more creative than that. Now, turning to paragraph 8, for example, paragraph 8 really causes me to doubt matters. My first reaction to that is, what gives content to Article 8 for us to be able to speak to the right to life of embryos and frozen sperm? That's potential life. So I have doubts about this. Are we going to use these paragraphs as primary sources for our communications and individual communications, or can we go beyond that? My position was always that general comments can go beyond the jurisprudence of the committee, because that's the added value we get through our general comments. And I think that 8 is going to be quite controversial in the light of that. And of course, the one before that, Article 7, or rather Paragraph 7. I think Paragraph 7 will give us a lot to talk about. There are a number of references to regional systems and the Inter-American conventions. The reference to the Inter-American one in 7 is good, but I think the interpretation thereof is an unfortunate one, because it explains how the Inter-American Court interprets the right to life in the case against Costa Rica on in vitro fertilization. I think that needs to be looked at to make sure we get those terms exactly right. So I will reserve the right to make specific comments on each and every one of these paragraphs. The document is very well drafted. It's a very good document, very well put together. It has virtually all of the issues which we had looked at. Once again, you will know what the right to a dignified life means to me, to the fact that people need to have a life project. So I'll be raising that. So once again, congratulations to the co-rapporteurs. Congratulations to the whole of the committee for wanting also to work with this Open Doors to Civil Society. Thank you very, very much. Thank you very much, says the chair. My next speaker on the list is Mr. Politi. Mr. Politi, you have the floor.
Thank you, Mr. Chairman. And first of all, let me thank very warmly the two rapporteurs, Mr. Shani and Mr. Sir Nigel Rodley, for the new draft that they have prepared after the general discussion that we had at the last session with national human rights institutions, civil society, and representatives of the academia. This is an excellent draft, an excellent basis for discussion, and again, I want to congratulate the rapporteurs for the quality of the text and for being so brave, as has been said also during this discussion. With respect to previous comments, 6 and 14, that date back in 1982 and 1984, the draft comment 36 will have a much more comprehensive and explicit nature, focusing on each of the sub-paragraphs of Article 6 and raising important issues of interest that will require, obviously, careful consideration by the committee. And I can only quote the question of abortion, the question of the use of lethal force in military operations, including the use of weapons of mass destruction, the issue of the death penalty and the relationship with the international humanitarian law. In this respect, I subscribe to the general comments made by my colleague Olivier de Fruville. I would say that together with the text that we have before us, Mr. de Fruville really set the stage for our discussion, for our debate. Now, I just would like to make a few other comments. With regard to structure, I agree with the structure of the text. I remember that during the discussion that we had, I think in March or April, there was a debate about the cross-cutting issues. They were indicated at the end of the text, and then somebody suggested to put it in the beginning. I have to say that I somehow was expecting maybe something like that, but as it is fine. Maybe there is something missing of the cross-country cutting issues, but we can get to that while we discuss the specific paragraphs. On the points of substance, just a few words at this stage. On the right to life and paragraph 7 of the draft, I realized that it was an attempt, a successful attempt to a large extent to balance different considerations and different inputs coming from civil society. I will come back with some suggestions when we come to the paragraph, but I think that the 2 points that were already mentioned today, the women's freedom choice and the question of family planning, improving the impact of family planning are important points. I still think that the text reflects still a pretty wide, maybe too wide possibility left to states to apply restrictions on the ability of women to seek abortion, but we can get into that at a later stage. The use of lethal force in military operation is another point of great importance, at least in my view. I think that in paragraph 13, it would be important to strengthen the paragraph by way of saying that the obligation of states parties to uphold the right to life includes the duty to ensure not only to ensure that in situations of armed conflict, military operations are consistent with relevant international law, including international humanitarian law and human rights law. In other words, instead of limiting the text to say that these aspects are regulated by the international humanitarian law, to set out, perhaps there is already something in the text, but it should be reinforced. The fact that this kind of activity by the states should be in strict compliance with international humanitarian law. And also, still on paragraph 13, the second part, which deals with the lethal autonomous robotics, perhaps we should include the notion of the state duty to be as transparent as possible about the same normative framework that would authorize target killing operations through robotics and armed drones. This is an issue of very high importance and very high relevance in today's international law of the armed conflicts. Imposition of the death penalty, I subscribe totally to what Mr. De Fruville said about the spirit of abolition of the death penalty included in the covenant. Obviously, the concept of the most serious crimes needs to be interpreted very restrictively, and this has been already underlined also by the UN Special Rapporteur on extrajudicial summary and or arbitrary executions, and I would like to refer to those conclusions. On paragraph 42, I go very quickly. I don't want to spend too much time on specific issues, but I think it is important to underline the need of conformity of the application of the death penalty for the most serious crimes with all the other provisions of the covenant, including Article 7, and this refers to the manners of execution, which is a very relevant issue here. And perhaps we should consider also the aspect of the prohibition of something like indefinite solitary confinement of those who have been sentenced to death, and the question of possible violations of the rights of the family of the person sentenced. And this is one aspect that I think should be considered. On enforced disappearance, I have only one comment, and this is more of a structural comment, actually. Enforced disappearance is referred to in a number of paragraphs of the text. Paragraph 6, paragraph 21, and paragraph 59. I wonder whether we cannot envisage a review of the question of enforced disappearance in relation to the protection of the right to life in a separate heading of the comment. I just leave this as a food for thought for people also who are more specialized than me, but it was kind of, I wouldn't say strange, but I would expect something refers specifically to enforced disappearance, and I subscribe to what has been said in these different paragraphs that I listed, but perhaps we could think of something that make more systematic the reference to enforced disappearance in relation to the right to life. And finally, I welcome the approach in paragraph 63 of the draft, in which rules of international humanitarian law are seen to be relevant for the interpretation and application of Article 6, recognizing that both spheres of law are complementary and not mutually exclusive. I ran into a 4 or 5 years old article by an American scholar, I think Weisbrot, who wrote excellent 50 pages on this aspect and how the Human Rights Committee addresses questions of international humanitarian law. I subscribe to most of what he says, but I think that particular attention should be given in that respect with regard to IHL, since the two bodies of law, human rights and international humanitarian law, they tend more and more to overlap So the aspects of the relationship between the two fields need to be considered, especially in relation to the protection of the right to life. Thank you.
Muchas gracias.
Thank you very much, Mr. Politi, for your statement. Ms. Vatterwal, you have the floor, madam.
Thank you, Mr. Chair. At this point in time, I don't have comments, general comments. I have specific comments when we come to the paragraph by paragraph consideration. But I want to congratulate Mr. Cheney and Sir Nigel for this excellent work. Thank you.
Muchas gracias a usted.
Thank you, madam. Ms. Zabit 4, please.
Thank you very much, Mr. Chair. I would like to join my colleagues in congratulating the rapporteurs for all their efforts in preparing this draft that we have before us. I think it's a very careful preparation of this draft, and we should wholeheartedly thank for all these efforts. I think that the drafting of the general comment gives us the opportunity to focus on this most important right, which is indeed fundamental to all other rights contained in the International Covenant on Civil and Political Rights, which is adequately also reflected in one of the first paragraphs of the draft. I hope that this opportunity will give us also the chance to give duly recognition to the imperative need to protect the right to life. I completely agree with the rapporteurs indicating that the general comment should primarily focus on previous jurisprudence that we have established so far. This has always been the practice of the Human Rights Committee. It gives us adequate guidance because we have already thought about specific issues before, and this will certainly influence the adoption of the general comment. I would like to stress that there is indeed, as has been stated before, a need for consensus within the committee, and I think that the discussions that we will engage in will help us to find enough consensus in order to make the general comment as persuasive as possible. Of course, the rapporteurs have given us a lot to think about. And we will come to these issues in due course. I won't go into the details right now. I very much look forward to engaging in this dialogue. Thank you, Mr. Chair.
Muchas gracias.
Thank you very much, madam. I would now like to give the floor to Mr. Situl Singh, please.
Thank you, Chairman. May I also join my colleagues in congratulating Mr. Shani and Sir Nigel in producing such a good draft. Mr. Shani has already alluded to one specific paragraph. I am not going into details, but on this point, I would like to join the stress on the comments made by Mr. Rodriguez Recia about economic, social, and cultural rights. And this paragraph 28 is so loaded. Each sentence refers to these, to such rights. I know that we can't quite, let's say, steal the show from the Committee on Economic, Social and Cultural Rights, but their general comments are useful on this score. And I also would like to make the link between our own general comment on the right to life and these references to social, economic, and cultural rights. So at this stage, this is all I have to say, Mr. Chairman.
Muchas gracias. Señora Pasartis.
Thank you, Ms. Patasis, please.
Thank you, Mr. Chairman. I just wanted to briefly take the floor, in principle, to congratulate the rapporteurs for what already appears will be a Herculean task. The right to life is an all-encompassing, one of the most fundamental rights, and the developments in the 30 years that have passed, 30 or so years that have elapsed since the previous comments, make it much more crucial to come back to this issue with a new general comment. Having participated in the public discussion last July, which was quite heated, very lively, I witnessed, along with other colleagues, the many views, diverging views, perceptions, and opinions expressed during that open debate. I believe the rapporteurs have managed to take into account the differing views. The draft presented before the committee adopts a comprehensive approach of the list of questions raised. The two rapporteurs have addressed all issues, even those considered to be, in quote, difficult. And this is very obvious in the first paragraph containing the general remarks, which is really a very rich part of the draft before us. The rapporteurs have taken into account a multitude of sources, both within the committee and its work and outside, which I think is positive. I would like to, as regards methodology, following the remark I made on the general remarks, say that I agree with this methodology of focusing on the negative prohibition, on the positive duty to protect, and I agree with Mr. Satulsing that there again we will have some issues on economic and social and cultural rights to take into consideration. And of course the separate examination of the issue of the death penalty, which of course is in Article 6 of our covenant, addressed in 3 paragraphs. So this is a very all-encompassing draft. I would also like to say that as regards the outcome, we will need to keep in mind that this draft, this general comment, once adopted, will serve as a guidance to the committee members as well, to the committee itself as well as to states. It will be addressed to states, but it will serve as the committee. In many times, the committee refers to its general comments in the views which are adopted in the process of communications, as well as in the adoption of concluding observations. So it is a source of the covenant provisions, but it is also a source to the work of the committee itself. For the new members, and I will close with that, I'm sure that this will be a very exciting experience. We all look forward to the discussions that will follow, and I am very happy to come on board in the committee at a stage where a new general comment is being discussed. Thank you, Mr. Chairman.
Muchas gracias.
Thank you very much indeed, Ms. Patsatis. I would now like to give the floor to Mr. Pusid. You have the floor, sir.
Thank you, Mr. Chair. Like my colleagues, I would like to congratulate the two rapporteurs for this brilliant work. Mr. Chair, this general comment focuses on a number of rights, such as the right to life, which is the father and the mother of all other rights. I don't think this right can be separated from any other rights. But we have to recognize that there are many various opinions on these rights. You have to take into consideration the culture, the specificities of countries. I'm talking about abortion and other rights and the relation between abortion and the right to life, also the rights of the embryos. And I think these questions are the subject of various opinions and various interpretations. I, of course, would like to thank the two rapporteurs who have tried thankfully to give us a balanced idea on the various opinions that have been spelled out. Of course, there are many other things I would like to talk about, but I'd rather talk about these issues when we get to discussing the report paragraph by paragraph. But in the meantime, given that the covenant has not been specifically mentioned, I think we should leave our last comment after the extensive discussion that will ensue. Thank you.
Muchas gracias a usted.
Thank you, sir. Thank you, Mr. Bouzid. I have two further speakers on my list. Ms. Cleveland now, please.
Thank you, Mr. Chairperson. Many excellent congratulations have been directed at the rapporteurs, and I would like to join them in thanking them and congratulating them for a brave and ambitious draft. It has been a Herculean project, obviously, to try to gather together the work of this committee as well as the work of parallel human rights bodies, particularly the regional human rights bodies, with respect to all of the issues that potentially implicate the right to life. And I greatly appreciate their assistance in putting on the table for us the issues that we need to consider. I think that the project to take on a new general comment on the right to life itself recognized the significant progress that has occurred since our prior general comments regarding recognition of positive obligations of states to recognize the right to life, progress toward narrowing and abolishing capital punishment, progress in protecting control of women over reproductive choice, and progress in understanding the relationship between human rights and international humanitarian law. These are all obviously issues that are addressed in this draft. I have specific comments with respect to some of the paragraphs, as I'm sure my colleagues do also. But at this point, I would really like to endorse and share the views of my colleagues in thanking the rapporteurs for their strenuous efforts on our behalf.
Muchas gracias, señora Cleveland.
Thank you, Ms. Cleveland. Mr. Benasho, did you wish to speak again? Yes, I simply wanted to react to the comments from certain colleagues. I entirely agree with them when they say that the right to life cannot be dissociated from rights that enable one to live a dignified life, the right to health, the right to education, and in more general terms, economic, social, and cultural rights. I would like to counsel prudence in this regard. Ensuring the right to life and guaranteeing the right to life is one thing. Guaranteeing and ensuring the conditions for living a dignified life are another thing. The two points are linked but separate, and I believe that Article 6 calls for discussion on the protection and guarantee of the right to life as such. And I find what has been included in paragraph 3 is sufficient in this draft. They indicate that the right to life concerns the entitlement of individuals to be free from acts and omissions intended to cause unnatural or premature death. I think we need to go no further than that. And in interpreting Article 6, we need to keep close to the core of this right, the right to one's very existence. And when it comes to a dignified existence, of course, that is connected, but it is not the purpose of our general comment.
Gracias.
The Chair, thank you very much indeed. Mr. Fatala, please.
Thank you, Mr. Chairman. I would like also to join my previous colleagues to congratulate the two rapporteurs on this issue. And I believe, as it has been said, that we cannot speak on any other right which is stipulated in the convention if we don't guarantee right to life, because if we don't survive, it will be useless to speak about any other life. And I believe that this should be pointed out in the general remarks of this paper. As for the debate concerning the issue of should we just focus on the right to life as life or extend it to cover also a decent life, I believe that if we take into consideration all the development for the last 30 years, which has been mentioned in this meeting, I think it should also cover the decent life, because if persons do not have a decent life, they can lose their life. For instance, if they don't have, if they cannot sustain themselves economically, if there are wars, if there are diseases, whatever is named in this paper, at the end we cannot guarantee for them the right to life. For that, I opt for the choice that when we speak about interpretation, new interpretation of Article 6, we should also speak about the decent life, because this is an integral part of Article 6, taking into consideration the recent development. Thank you, Mr. Chairman.
Muchas gracias a usted.
Thank you very much, Mr. Fatala. Very well. It's clear that there is a great deal of interest on the part of the committee. This has been a very interesting and significant first round of statements from committee members. For my part, I can say that this will be a major challenge for the committee. We have to bear in mind what the committee has said to states and also what it has not said to states. With regard to the committee's findings on violations of the right to life, we need to bear in mind also cases where the committee has not found a violation of the right to life. In considering states' reports and also on individual communications, it is also important for us to focus on the protection of the right to life within the framework of international law, seeing where possible to ensure that we leave aside our own personal views and beliefs. We should not try to tease out of Article 6 things which are not in it. And I think that will be a challenge for us all, including myself. With this said, I'd like to give the floor back to the two rapporteurs to react to the comments made by committee members. Mr. Shani first, please.
Thank you very much. I truly welcome all of the interventions. I'm very appreciative of the positive remarks that have been made. And I look forward to discussing the issues on as we go along on a paragraph by paragraph basis. I think some of the points that were raised were already a preview of what we are going to be discussing. I think the issues are very interesting and challenging. Our goals, I should say, and Sir Nigel will correct me if I misspoke. I think that we saw our mission as not designed to necessarily provide a text that reflects our own views of these issues, but rather a text which we think will captures the past work of the committee and that has a good likelihood to be accepted by the committee as a platform for future development. With respect to the point made by Mr. Rodriguez-Recia about precedents, I fully agree that the committee shouldn't be stuck in the past and that we could gradually develop our jurisprudence. I think the general comment is a very good way to go about it, which actually takes stock of everything that we have done, identifies gaps between the findings that we have reached and perhaps between the findings that we have reached and developments in other areas of the system. And then we can, if we can find consensus to move forward, and I hope this process will facilitate this, then I would be very happy to push it forward. I think the draft tried on some issues to move a little bit beyond the existing jurisprudence, and of course, whenever we will get to these issues, we will flag it when we introduce these paragraphs. So I think I should stop now, and perhaps Sir Nigel will take the floor.
Muchas gracias.
Thank you. I will indeed give the floor to Sir Nigel.
Thank you, sir. And I certainly don't disagree with my co-rapporteur. The basic role of general comments and certainly the basic role of the first draft of general comments has essentially been to take as the starting point the positions taken by this committee. It has essentially been a codificatory process. That doesn't, and that shouldn't be neglected. It's important. We shouldn't think that we're starting with a clean slate and suddenly drafting from zero. Otherwise, we're not going to get very far. And I'm very grateful for you for having made that point, sir. We are trying to give effect to the corporate accumulated wisdom, for want of a better word, of this committee. That doesn't mean, however, that we have to take everything done before as frozen in time, and we can't evolve in our views. I prefer the word evolve to go forward, because there's always an assumption that if you change your mind in a particular direction. So when we come to particular issues, we will discuss what best reflects that acquis of the committee in the context of how we see the covenant now from this point. I want to underline Mr. Shani's point that this text does not necessarily reflect our individual views. I don't agree with everything in this text myself, but I don't think the text is about our individual views. The text is about how the committee as a whole, operating under appropriate canons of interpretation of international conventions, perceives the meaning of the convention. And that involves a certain self-discipline. I, for one, and I am throwing it out as an example, happen to be a woman's right to choose believer. But that doesn't necessarily mean that I believe I can just impose that either on the committee or on the states of the world who are the parties to the covenant. And so we're going to have to try and work out how to get that right. And my final point is about the overall philosophy that guides us. The preamble to both covenants has high up the basic fundamental underlying philosophy of the covenants and of human rights in general. It's also in the Declaration, the Universal Declaration, recognizing that these rights derive from the inherent dignity of the human person. The Human Rights Project has been very successful. As a result, a lot of people want to get a lot of causes into the human rights construct. And when any particular right is under discussion, a lot of people want to get their right subsumed under the right that's under discussion. And of course there is cross-cutting, Mr. Politi's word, that there are cross-cutting issues, and we're going to have to, and are obliged to take them into account. But let's not fall into the trap of saying, well, this involves human dignity. The right to life is about human dignity primordially. Therefore, the right to life is about everything that is a human right, because that way, it seems to me, we will not be giving very good guidance either to ourselves or to states parties or to anybody else. What we need to do is try and figure out that which is specific to the right to life while recognizing the cross-cutting dimensions. It's what we've tried to do. Neither Mr. Shani nor myself, I think, are wedded to any particular language. Far from it. We have really both come into this process in the spirit which so many of you, so many colleagues have so kindly indicated, which is one of trying to create a basis for an effective discussion by colleagues, a discussion that we're both looking forward to. But it's a discussion that does perhaps need to be disciplined by some of those criteria that you mentioned, sir, and that I guess I have just repeated and that Mr. Shani has mentioned. So with that, we look forward to getting to grips with the text. It would be, because there are so many controversial issues in this text, there is a risk that we get bogged down. I don't envy you your task in the chair to move us along, because you're going to have to try and move us along, and we know that you're going to be very helpful to the committee in rising to that challenge. So with that, thank you for giving me the floor, sir, and thanks to all the colleagues for all their kind words and their constructive suggestions, and look forward to the continuing discussion. Thank you, sir.
Gracias a usted, Sir Nigel.
Thank you, Sir Nigel, for your words and your expression of trust in me as chair. Let us begin with our paragraph by paragraph reading. I dare say that the first paragraph will not throw up any major problems. Allow me to give the floor to Mr. Shani to present this first paragraph, which is essentially the update of our general comment. Mr. Shani.
Thank you. I hope that at least this paragraph will not give us a lot of room for discussion. Just to acknowledge perhaps that the two general comments before us were very short, and as a result, our ability to draw upon them was fairly limited, though we did try to maintain the essential elements, especially of general comment number 6. Here, with respect to general comment 14, Mr. de Frouville has mentioned the issue of weapons of mass destruction. We do allude to that in the draft, but using somewhat different formulations than general comment 14. And when we will get to that, we will, of course, have to discuss it. But I have nothing more to say about the first paragraph.
Bien, muchas gracias.
Thank you very much. Mr. de Frouville, please. Thank you, Chairman. You're right, I don't think this paragraph is going to bring up much discussion. I simply wanted to talk on method rather than substance. Paragraph 1 indicates that this general comment replaces earlier general comments, number 6 and number 14, and I wanted to know whether, in addition to replacing them, it revises them, i.e., I want to establish whether we are starting on the basis of acquis. I think Sir Nigel alluded to that point quite rightly, and I am wondering whether these two general comments can be considered as part of the acquis and as such should be incorporated in toto into the new general comment, or, on the other hand, whether this general comment reconsiders certain issues that have been covered by previous general comments. and may go so far as reconsidering and revising some of the views expressed by the committee therein. I think this is important because it will predetermine in various cases some of the wording that we adopt in covering points that were already addressed in previous general comments. Thank you.
Muy bien, muchas gracias.
Thank you very much. Anyone else? Mr. Rodriguez Recia.
Y yo creo que la discusión.
I didn't think this was going to be as peaceful as it has been so far. I agree with Mr. Olivier de Frouville. If the word replace is the correct word, or perhaps you could use another expression, whereby some issues that are not completely covered here can remain alive in some of the paragraphs or some of the interpretations, then I would like it to say that the current general comment covers and complements or adds to, but this replace would mean that all the other items are subsumed. So this we need to discuss. This we need to see how far this is complementary. Thank you very much, says the Chair. Mr. Benachour.
Monsieur le Président.
Chair, the wording we've used in general comments previously, and in particular 35 and 34 general comments, is exactly the same expression used by the rapporteurs in this one. In 35, on Article 9 of the Covenant, and General Comment 34 on Article 19, for both of these we used exactly the same wording. In Para 1, we said that this General Comment replaces, etc. Now, if this time round we use a different wording, then people will wonder why. People will ask themselves, what is going on here? So what we should do, therefore, to ensure that our general comments are stable and consistent, it would be better for us not to change the wording we are in the habit of using, and which are, as I said, the same wordings as used before, failing which doubt will be cast or complexity will be added to the reader's reading thereof. Thank you.
Muchas gracias.
Thank you very much, says the Chair. Now, this wording is adopted because this is a general comment bringing matters up to date. So, if we believe that there's anything in previous general comments must be reflected here, and we find that it's not duly reflected here, then we need to find the place to put that information. But the ideal would be to keep the wording as it appears now in Para 1, namely, this general comment replaces, indeed, prior general comments, or earlier general comments. If I could turn to the rapporteurs now for them to react. Now, of course, I'm saying this in my personal capacity, not as a chair. So, if I could give the floor to the rapporteurs, perhaps Sir Nigel?
I'm not sure if I'm speaking for both of us. It's a very interesting point that has been raised by Mr. de Frouville and Mr. Rodriguez Recia. And equally, it's not desirable in principle that we change the practice of the new general comments replacing the old general comments. But I also can envisage a situation in which we find ourselves agreeing on text which isn't necessarily coincidental with the previous general comments, and yet where some colleagues, enough colleagues feel strongly enough about the content of the previous general comments that they want to feel that those general comments haven't been abandoned, or some of the content hasn't been abandoned. My own suggestion at this stage is a procedural suggestion, that we provisionally, not just for, we provisionally adopt as first reading text text, but it's only provisional. We can come back to it before we conclude the first reading. The text as it is now, as proposed by Mr. Shani and myself, but just all of us making a mental note that we may need to revisit the word if it's necessary to develop a consensus on substance elsewhere in the text. I don't think I can put it any differently from that. So that's the recommendation. We keep it. I wouldn't even put the word in square brackets. We keep it as it is, but we just work hard not to forget that we can revisit that word replaces if colleagues aren't satisfied about other aspects of consensus that we arrive at on the text itself, on the current text. Thank you, sir.
Muchas gracias.
Thank you very much. Colleagues are also invited to look once again at earlier general comments and to draw our attention to occasions where they believe what is contained in old general comments is not actually picked up again by the new general comments. So once again on one, can I adopt one? One is adopted. Paragraph 2. Just before, though, we move on to 2, though, I'll give the opportunity for the rapporteurs to introduce 2. I know colleagues really want to take the floor because they're enthusiastic about it. Mr. Shani, you have the floor to introduce 2.
Thank you, Mr. Chair. So paragraph 2 uses some of the more hortatory language, which was used in the previous general comments and in a couple of our communications, which discuss the importance of that rights. There have already been some suggestions by members to add perhaps additional language from the past general comments, and as Sir Nigel said, we are not wedded to this particular formulation and would welcome additional suggestions. Thank you.
Muy bien.
Very good, thank you. Mr. Rodriguez Recia.
Sí. Justo.
A comment on the first line. I'm reading the Spanish version thereof. It says that Article 6 recognizes and protects the right to life of all the persons in the Spanish, las personas, in English, all individuals. Now, if I read the Article 6, it says human person. Now, I like la persona humana, the human person, as appears in Article 6, not just because it appears in the text, but because it excludes what might appear obvious to us, namely other form of persons, namely legal or natural persons, legal persons, that is. And that might not be entirely obvious when, I don't know, shareholders, for example, might claim the rights of their personal rights in connection with a business enterprise, etc. So I would be in favour of us using Article 6 language, namely, every human being has the inherent right to life. So, in English, every human being, as opposed to individuals. That was my first comment. To ensure that 2 has the same scope as Article 6. Thank you very much, says the Chair. Mr. Fatala, you have the floor.
Thank you, Mr. Chairman. As I have previously stated in the general comment, I would like to strengthen the last sentence of paragraph 2, which start with "it is most precious for its own sake." The second part of it, for me, is a little bit should be strengthened, which start with "but also serve as a basic right." I think it's better to have it, and that without guaranteeing such right, which is the right to life, the enjoyment of other rights stipulated in the covenant could not be invoked or addressed. Because if you don't guarantee the right of life, there is no way to speak about other life, as I have made in my general comment. I will repeat it. It is most precious for its own sake. comma, without guaranteeing such right, the enjoyment of other human rights stipulated in the covenant could not be invoked or addressed. Thank you, Mr. Chair.
Muchas gracias.
Thank you very much, Mr. Fatala. Mr. Benachour.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. First of all, I agree with the proposal made by Mr. Rodriguez Recia. On that point, I think he's right. We could write in the first sentence to strengthen it in the following way. Article 6 recognizes and protects the right to life of all human being or human person. It doesn't really change the current wording that much, but it strengthens it. So every human being or human person, toute personne humaine in French, human being or human person. Second comment, if you look at the third line, I would prefer us to say the right to life. Currently has profound importance. Now, right now, we've got the right to life has profound importance, line 2 in English. I prefer the wording of number 6, the previous number 6, and to say not just profound importance, but crucial importance, importance capitale in French, crucial importance. I believe, in French at least, capitale is a lot better. The right to life has crucial importance, importance capitale in French. That was my second comment. My third comment is this. Turning to the last line, virtually, in the French version. Now, the rapporteurs have used the expression basic right in the last line. Basic right. If I'm not mistaken. Yes, that's right. They've said basic right. As in, but also serves as a basic right. Now, in the French, it has been translated as un droit de base. Un droit de base. I don't know what Monsieur de Frouville thinks about this, but I don't think that's very wisely chosen. Un droit de base doesn't really fit well in the French. So I would propose that in the French version, instead of saying droit de base, we say droit fondamental. Droit fondamental rather than droit de base. I also feel, I'll conclude with this, I feel that Mr. Fatala is right when he says that we should strengthen this fundamental nature of the right to life, or basic nature. I think we should say a basic natural right inherent to the person facilitating the enjoyment of all other human rights. So, my proposal is this, to get rid of droit de base and use droit fondamental in the French for basic right, and then to strengthen this right to life, I would add a short sentence which would say, this is a fundamental and natural and right which is inherent to human beings or to the human person, which facilitates the enjoyment of all other human rights. Thank you.
Gracias.
Thank you very much. Mr. Benachour, says the chair. Monsieur de Frouville, you have the floor. Thank you, Mr. Chairman, very much. Well, first of all, I'd like to support a number of proposals we've heard thus far, taking them in the right order. I believe that the first sentence, indeed, Article 6, recognizes and protects the right of all to life of all human beings or individuals, should be strengthened. In the light of what has been proposed by Mr. Rodriguez Recia, so human beings instead of individuals, and that was supported by Mr. Benachour just now. I also think that it would probably be appropriate in the second sentence to use the wording that was adopted in General Comment number 14 in paragraph 1, where we said that Article 6 is the supreme right allowing for no derogation. We added even in cases of exceptional circumstances. We could even add a reference to Article 4, which would render matters clearer, at any rate, for the reader who is not necessarily familiar with the covenant, because the derogation issue is not explicit in itself, it would be explaining it slightly. In the third sentence now, I support what Mr. Benachor proposed, namely in the French, we should change it to what Mr. Benachor proposed. I believe that his proposal for the new French version would render it better. He said capital, not primordial, capital for profound. Capital was a very good expression that at least reads a lot better in the French version. As to the last sentence now, the expression droit de base for basic right is not good, and therefore droit fondamental, as Mr. Benachor proposes, is much better, droit fondamental, because it refers to the idea of this being a foundation for rights without necessarily sending off this idea of the hierarchy of rights, because sometimes when we talk about basic rights or supreme rights, we tend to introduce the idea that there's a hierarchy in rights, and yet there is no hierarchy in rights. No, they are interdependent. At the same time, though, the right to life is a foundational right, a basic right. So the notion of droit fondamental, fundamental right, would be a good notion to use in the French version. We could also use the expression used in paragraph 1 in reference to General Comment 14, wherein the committee said the right to life underpins or is laid down as a foundation for the other rights. So Mr. Benachor's proposal for the French is much more elegant, I believe. And finally, and I'm sure I've forgotten things along the line, we had Mr. Fatala's proposal, I think that echoed Mr. Rodriguez Recia's proposal, and I agree with him as well, namely to strengthen the first sentence. Thank you very much. Thank you very much. As the chair, I have 3 further speakers on my list, namely Mr. Bouzid first.
Thank you, Mr. Chair. Actually, I have a proposal in terms of the first sentence. We would say that Article 6 protects, recognizes and protects the right to life of all individuals, human beings, or whatever. In Arabic, we have 4 or 5 different words that have the same weight and same meaning. So we can say individuals, human beings, humans. So I would like to propose to add all individuals without discrimination, because we understand that countries in certain occasions might recognize the right, but when it comes to protection of the right on the ground, there might be discrimination on a religious basis or racial basis. So I propose that we should use all individuals without any discrimination. All individuals without any discrimination. Thank you.
Thank you very much. Mr. Lashlik.
Mr. Lick?
Mr. Jelic.
You didn't ask, no. Oh. Perdón, la tenía en mi lista aquí.
Apologies, I had you down on my list. Because we like to hear you, actually. But we will have a chance later on to do so, I'm sure. Ms. Cleveland, I also love to hear you, and I love to hear everyone in this committee, obviously. Ms. Cleveland, you have the floor.
Thank you, Mr. Chairperson. I'm sure you love to hear from everyone in the committee. I generally concur in the suggestions that have been made about strengthening this paragraph, and I was just asking to take the floor to make 2 points about issues that were mentioned in the prior general comment number 3 that were not taken up either in this paragraph or in the first section of this draft general comment, and that is in general comment 3 in paragraph 2, we include the language that the right to life is a right which should not be interpreted narrowly. And it's not clear from the prior draft whether that was simply a reference to the fact that states tended to report on it narrowly, or if it was making a broader point about the right to life. but the language isn't included here, and perhaps the rapporteurs would want to comment on that. And then with respect to the second issue, in general comment 6 and 14, in paragraph 2, we directly take on the problem of the scourge of war and the duty of states to prevent war, to avoid war, to bring wars to a close, to minimize deaths through war. And this issue is now taken up at the very end of the general comment, primarily in paragraphs 66 and 67. And I was just wondering, given the sort of devastating implications of war for the right to life, and also the quantity of war we have seen in recent years, whether we should restore the primacy of that consideration in this draft. Thank you.
Thank you very much. I will at this stage give the floor back to the rapporteurs for them to react to this matter. But just to say, before we move on, in the English version, it speaks of individuals in the first line of paragraph 2, so it refers to the persona humana in the Spanish. The Spanish version, however, just says persona, but the English version says individuals. I'm just pointing that out for you to know exactly what you're working on, and also for the people working on the English version to be aware of what the other version says, versions say. And with regards to the last paragraph, just remember the right to life is a source of the enjoyment of all the other rights. That's a concept you need to remember, which is something that echoes with what Mr. Fatala was saying in his comments. But any wording, as far as I'm concerned, would be good. But that's just something else I was adding to that. Mr. Shani, you have the floor.
Thank you, Chair, and thank all the colleagues for their very good comments. And I think all of them are good comments which should be taken on board. Maybe the way for us to go forward, maybe Sir Nigel wants to, if he has any reservations on any of them before I make any practical suggestions as to how to move forward. So maybe Sir Nigel should take the floor now.
No, I don't have any reservations on the basic understanding behind the different proposals, that there may be textual issues. Clearly there's no problem about using the Covenant Article 6 paragraph 1 language of human beings rather than individuals, and we'll just stick to the Article 6 language, which should then be exactly the same as in the actual official Article 6 paragraph 1 of all the different language versions. So we're not in the business of trying to redraft. I think we can be inspired by both paragraph 1 of General Comment 6 and paragraph 1 of General Comment 14, which track very similar notions in very similar language. There's no harm in bringing that in. I want to be a little bit careful about the war dimension, but I think we can perhaps bring it in the context of again using the existing language in General Comments 6 and 14 on non-derogation, and we can bring the war dimension in through that way. Yes, I think there are the elements for a redraft that we now have, but I don't think we can. I think we need to do it exactly the way we normally do it, and that is when a redraft is sufficiently complex, the rapporteurs need to go away and come back with a text that reflects the discussion, and that's what I think Mr. Shani and I should be doing now. Thank you.
Thank you very much, Sir Nigel, of course. That is what will be done. We're not going to put pressure on the rapporteurs right now for them to incorporate all of these proposed changes. But just to say that the first two paragraphs of, or rather the first two sentences of paragraph 2 covers what the committee already said in its general comment number 6 and general comment number 14. So that's something we should also bear in mind. Mr. Shani, I see we're fast approaching 12 o'clock, which is the end of our meeting. Mr. Shani.
So apparently we're not going to approve the whole first reading today, so it seems. So just perhaps on some issues that I think we would appreciate to have some clear guidance from the committee. So let me perhaps go briefly over the proposals that had been made with respect to paragraph 2 and express where I think we may need some more information or some more advice. So with respect to the first sentence, I think there wouldn't be any difficulty in accommodating the proposal that we would, made by Mr. Rodriguez-Recia, that we would deal with human beings as opposed to individuals. Mr. Bouzid offered that in this sentence, we would also introduce the concept of without any distinction or without discrimination. So if any member of the committee wishes to make any suggestions in this regard, it would be greatly appreciated. But I think this shouldn't be it would, as I see it, it would follow the language of Article 2.1 of the Covenant and the allusion to distinction. With respect to the second sentence, Mr. De Furil suggested that we would, after derogation, we would spell out the derogation even in exceptional circumstances or language of that sort, and perhaps echoing the point made by Sir Nigel, we could allude specifically here to wars and other exceptional circumstances to tie in the issue of even in times of war, this would apply. There has been a suggestion that we would change the word profound to the word crucial. I think it was raised in the context of the French version, but I don't see a major problem replacing it also for the English version. With respect to the third sentence, we did have a few ideas, and here we would have to engage in some drafting. So the issue of inherent right was proposed, that we would, when dealing with the precious nature of the right to life, we would also allude to the fact that it is inherent to the human person, and that we will, in a way, reverse the other sentence, the structure of the second part. Instead of basic, we will use the term fundamental, which translates better into French, and perhaps is less Kelsenian in nature. And with respect to the latter part of the sentence, we would, according to the proposal made by Mr. Fatala, we would use a formulation which goes along the lines of without which all other human rights could not be guaranteed, or something of that sort. We will find the specific formulations, and then Madam Cleveland proposed that we will also draw language from General Comment 6, I believe, that this is a right which should not be interpreted narrowly. So I think these are the elements that have been proposed. All of them appear are acceptable to us, the rapporteurs. So I think on that basis we will provide the committee already for the next session, we will provide a new draft formulation so that we can adopt paragraph 2.
Muy bien.
Very good. Thank you very much for that. That is how we will proceed. This is a first reading, and as such, I'm going to accept all kinds of suggestions at this stage. Then, as we work further on this, I will be asking colleagues that as they see their proposal reflected in the text, then I will ask colleagues to entrust the rapporteurs with the drafting. Otherwise, we will become an 18-member strong drafting committee, which would severely hamper the work of the rapporteurs. So, and I want to protect, so to speak, them in that endeavour. We have just a few minutes left, well, about 10 minutes, in fact, left to work on this. So, moving on to paragraph 3.
Señor Shani.
Mr. Shani.
Thank you. So paragraph 3 is designed to offer a general definition of the right to life, to delineate the scope of coverage. There are two issues I would wish to flag beyond, of course, the definition itself. One is the issue which has already been raised in the general discussion of a dignified existence. We tried to find language that would capture this idea. This was an idea which was strongly presented before the committee during the open session, during the civil society session. And I think there is much to be said in favor of an approach which understands the right to life not as a right to bare life, or but life which is worth living. Of course, this is something which I think we would need to discuss. And with respect to the last sentence, the issue, there is always an issue of when you are formulating these sort of lists of illustrative examples, whether you want to be long or short, because once you start being long, then there are questions as to why are you including this or that. And we have decided, and also there are sometimes sensitive issues, namely that even putting a question mark whether a certain life needs protection or not is already maybe sending the wrong message. So we have chosen to deal with one particular area, which is an area which the general comment deals with quite extensively, namely the death penalty for criminals and the use of extrajudicial killings in the context of the war on terror. But as indicated before, we are not wed to this formula. We really look forward to hearing comments from the committee, whether we want the allusion to terrorist crimes or whether we even want the allusion to serious crimes. So this is what I have to say at this point.
Muy bien, muchas gracias.
Thank you very much indeed. I already have 3 requests for the floor on my list. Mr. Rodriguez-Recia first, please. Thank you, Rapporteur. I will start at the end. That's the only point I would like to comment on. General comment 35 had a similar paragraph, and we have continually discussed whether we are going to have an open-ended list or a closed list in such circumstances. Let's look at the paragraph. Or last sentence rather, I would be tempted to remove it completely or make reference alternatively to the rights of all persons, not simply those suspected or convicted of serious crimes such as terrorist crimes. Because this is shifting sand that we're moving on here, and if we address terrorism, then we might also need to list other circumstances to avoid exceptions and exclusions, and questions as to why terrorism was included or not. This sentence begins by saying Article 6 guarantees this right for all individuals. We already said this in the first line of 2, so we have repetition, almost word for word. So I would prefer to see that sentence either completely deleted or retained, but with a more extensive list to avoid any potential speculation as to why we made such a specific reference to the topic of terrorism. Thank you.
Muchas gracias, señor Rodríguez.
Thank you, Mr. Rodriguez-Recia. Mr. Iwasawa, please.
Thank you very much, Mr. Chairperson. I'd like to make some comments on this term, a dignified existence. I do understand that we need to discuss whether a life is worth living, and this may have implications on euthanasia and other issues within the scope of Article 6. But I have some reservation because this word may go beyond the scope of Article 6 and go too much into economic, social, and cultural rights dimension. Because it seems to suggest that Article 6 covers, for example, the right of everyone to an adequate standard of living provided in Article 11 of the Economic, Social, and Cultural Rights, or the right to Social Security in Article 9, or the right of everyone to the enjoyment of the highest attainable standard of physical and mental health in Article 12, and so forth. So although I do understand where the concept is coming from, but I'm not sure if this word is really the appropriate one here. Thank you.
Muchas gracias.
Thank you, sir. I have 5 requests for the floor. Mr. Politi, please.
Thank you, Chair. Still, with regard to the dignified existence, I strongly support the inclusion of this concept, which does not necessarily refer, in my view, to the economic aspects of the existence, but to the dignity of human beings, to the fact of being free from, for instance, torture, inhuman treatment, trafficking in human beings, and all of that. These are dimensions that I think should be considered in our text. And in that respect, I also wonder whether it is sufficient to say legitimate expectation. If we talk about the entitlement to the right to life, why don't we talk about the entitlement to enjoy a dignified existence? I think this should be a matter of discussion for us. Thank you.
Muchas gracias, señor Politi.
Thank you, Mr. Politi. Mr. Bouzid, please.
شكرا سيد الرئيس. أيضا أنا بالنسبة لي فهمي على الأقل لمسألة العيش الكريم بالنسبة لا معنى لحق الحياة.
As far as I'm concerned, with regard to a dignified existence,
بالنسبة
the speaker begins again with regard to dignified existence. I wish to indicate that a dignified existence is meaningless in and of itself if it is not understood against a broader backdrop. Economic, social, and cultural rights may come into play, but there's a need for minimum considerations. Good health and freedom from the threat of hunger and abject need or poverty. And if those rights are not considered, then it is not possible to conceive of a dignified life or dignified existence. Life needs to be considered as a series of indivisible rights, and as such, there is a need to address those concepts such that they can be dealt with in a broad and less restricted way than in the past. I thank you.
Muchas gracias.
Thank you, Mr. Benashur, please. Thank you, Chairman. I would request that paragraph 3 be left in its current form. I find it to be balanced, and I agree as to the need to refer to terrorism in this paragraph. Allow me to tell you why. At the current time, a number of states are adopting legislation on terrorism and are re-establishing the death penalty on the grounds that terrorism is a particularly serious crime that justifies the re-establishment of the death penalty. That's the case in my country, for example. Tunisia hitherto had not applied the death penalty for some time, and it seemed that it was moving towards abolishing it. Now, in legislation on terrorism, in the wake of recent events, the death penalty has been re-established in Tunisia, and I think it would be appropriate to remind states that the protection of life needs to be guaranteed even for the most serious crimes, including terrorism. So I, for my part, would like to see the current wording retained. Thank you.
Muy bien, muchas gracias.
Very well, thank you, sir. Says the Chair. Allow me to inform the committee that a number of requests have been recorded. I have 6 requests for the floor at this point. And I'm not, in view of the importance of the discussion, going to ask you to speak quickly or cut down your statements. So can I suggest that we suspend the debate at this point? I dare say that the rapporteurs have taken due note of the points made by colleagues up to now. I have noted that Mr. Vazlashvili, Mr. de Fourville, Mr. Fatala, Mr. Singh, Ms. Cleveland and Ms. Zybert wish to speak. This will be on Wednesday, at which point we will be discussing the draft general comment again as of 4 p.m. I wish to make this information known also to civil society observers and those present in the room. We will be convening a public meeting at 3 p.m. on methods of work, and then at 4 p.m. we will be resuming our discussion of the general comment. Allow me once again to express my gratitude to all colleagues for their input to this very exciting, enriching discussion. And allow me once again, in the strongest possible terms, to congratulate Mr. Shani and Sir Nigel Rodley, the rapporteurs, for their very high quality draft, which serves as a splendid basis for our discussion. At this point, I would like to adjourn this public session, and we will take a 5-minute break before moving into a closed session with civil society representatives and United Nations agencies looking to forthcoming state reports. The meeting stands adjourned. A 5-minute break will be taken. Could I please ask those who are not participating in the forthcoming closed meeting to leave the room at this point? Thank you.